say ye in the Indians Kofaba, Yasako Fafo Ede Aba, or my Ghana with the Sawapa, your summer would wapani and Memodia, and ye. To me, in yin in the news and no in Sincha the Birada. And today, I may catch us subscribe to your channel no. Also, all other relevant news are and can for politics one, any governance, any idea. Say for political parties, NPP, NDC, CPP, PDP, and other political parties, no so. Osabeka won se mo ha ede na asesi bio a ama atumpan ana ama yenya asundwe e wo sete domasi yenkotie nsem bi emra pedefo ase ka kom jeje no kofo enum nti mentumi nkansam nso mfa nhye nkofo bia no yenkotie mra na ye ba ye de adwenche ba hwese wutie no no comment nso bi gu ase na bibia nso aye kama ne atuma nya bre akenkan e de ama before that nso no subscribe to your channel no on Sabeka all other relevant news yetie nsem mra sisi a na ye ba ye de the akabia nso atwa wo so na bibia nso aye wana yenti mresisi
a discussion that has two compelling arguments. So the former Chief Justice contends that the process that has been carried out so far is to remove her as Chief Justice. No process has been carried out to remove her as a Supreme Court judge. Therefore, the warrant to remove her as both is not lawful. She believes that she remains a Supreme Court judge. Kofi, I think the simple question is, if you have been found to have engaged in stated misbehavior, how can you remain a Supreme Court judge?
Well, good morning again. Point is this. So let's assume you are one of the journalists or anchors of Super Morning Show, and then you are appointed to be the head of the team. All right, and for some reason you are removed as the head of the team. Does that mean you are removed from being an anchor or a journalist on the Super Morning Show? I am saying this because on radio we can't go through all the things and we need to simplify them. The issue is this. There are justices of the Supreme Court. In our law, they are appointed in a particular way. Then there is the Chief Justice, who is one of the justices. In our law, she is appointed differently, goes to vetting differently. There is, in our law, a process for removing justices of the Supreme Court. That is different from the process of removing the Supreme Court justice. I am saying this simply because even in our law, there is the admission that there is a difference in those two positions. Now, what we all must understand is that as long as there is room and the process have not been exhausted for a matter that is in contention to be declared or properly sorted out or explained, we should use that option. What CJ Torkorno is doing is useful for all of us. You hear people talk about, oh, it's not good. She's disgracing herself. Why is she seeking to come back? Honestly, the rest of us are better beneficiaries of this than CJ Torkorno. Just like we keep quoting the Egyptian case. When some of these things are brought to the Supreme Court, it gives opportunity to express them better, explain them better, give more elucidation on them. So what we must look at the beginning is this. She does have the right to bring that matter. Because until there is a judicial pronouncement on the matter, it is not final. And two, there is persuasive argument in law that what she's saying may be true. To the extent that there has not been any variation on it, all of us should hold our horses and not sound as if we know how this is going to go. At least let the process be gone through and let there be a clear declaration. Then in future, we don't have any of these problems. So for me, I'm not saying it is right or it's not, it is good or it is not. I'm simply saying it is useful to clarify that area because it is not clear. There is a difference in the Supreme Court justice and the Chief Justice. And the things that the Supreme Court justice does, which is mostly being a judge, are different from what the Supreme Court Chief Justice does, which include administrative work. And the other justices don't do as much as he does. So there is persuasive argument that if you say I cannot be head of the team, one of the justices becoming a chief justice can no longer be a chief justice and perform those administrative duties. And I have earned my place already as a Supreme Court justice. Then if you use the bullet that removes a chief justice, it cannot kill those two there. But there is also an argument to the contrary, which I believe my good friend and colleague will canvass here. What we need to appreciate is that it is a proper case to come before the court and let the court handle it, so we will all be better for it.
Kofi, blessed here. I just wanted to point you to Article 128 of the Constitution, which talks about composition and the mode of exercise of judicial power. You look at 1284, and it reads that a person shall not be qualified for appointment as Justice of the Supreme Court unless he, and we can use that to replace she, is of high moral character and proven integrity, if not less than 15 years of standing as a lawyer. Does that not tie, ethics and standards to who qualifies to still remain on the bench of this country?
Well, you're right. But that's the point. She qualified to become a justice of the Supreme Court, which means she passed all of that. Then when you become a justice of the Supreme Court, you are picked from the team to become the Chief Justice. Okay? Now, when you are removed as Chief Justice, it does not mean that the qualification that brought you to being a justice of the Supreme Court is all of a sudden removed. Because what moves you from the justice of the Supreme Court to the Chief Justice is different.
Is stated misbehavior not a proven case of breaching high moral standards or character as stipulated in 128 of the Constitution?
That's not the issue.
Why is that not the issue, though?
Well, that's not the issue because he passed all those things to become a justice of the Supreme Court. Okay? And now she's moved as a primus inter pares to become the Chief Justice. She's all of that plus. If she is dropped from the position, like I said earlier, if you are made the head because they think you have some leadership, special leadership qualities, and therefore you're made the head of the team at the what is your program called? Morning show. Okay. And for some reason, you are removed because you didn't do that job well. I think there's an argument that you should be returned to your original position. There is this thing in HR called being promoted to your point of ineptitude. Some people are good at a point. When you leave them, they may not be that good at that point. So I'm simply saying, the processes have not been exhausted. There is an argument to be made. Whether it will go in her favor or not in her favor, it is useful for the rest of us that this matter be put to rest once and for all. What I say, or what my colleague Martin will say, is not the law. These are our views. It is properly before the Supreme Court. Let them take a look at it and let them make a decision on this matter. And then we will all be advised going forward. But I do think that she does have a case. Because in future, if you become a justice of the Supreme Court, you may be very suited to become the Chief Justice. But if you look at what is going on now, and you are giving the Chief Justice, which can help the whole country, you will refuse. Simply because anything, including making a mistake on accounting, can lead to your removal of the Chief Justice, and then you also get removed as a Justice of the Supreme Court. Very good people will refuse to take that position simply because it puts them in bigger jeopardy than the benefits that they gain from being in that position. So I'm simply saying there is room to look at this and let the justices of the Supreme Court deal with it. Right. In a constitutional republic, nothing is final until there's a final judicial pronouncement on it or the statute of limitations passed. So to the extent that she has not exhausted all these, I think it is proper to bring this matter. Right. People are giving her advice and saying it's not good, you are disgracing yourself, you stop fighting. All of those things I don't think are the law.
Okay.
she is good enough to advise herself, and she has advised herself. I am happy that she's doing it, and I think I'm waiting for the outcome.
All right. Now, Martin Kpebu is here, but just before I bring in Martin, I'd like to get your reaction on this very quickly. There are some who suggest that this is a matter that has actually already been ruled on by the Supreme Court. And they point to Justice Kpega's ruling in the case that came before them, Ghana Bar Association versus Attorney General. This was back in 1995-96. And I'm just going to read because it's a very short paragraph from Justice Kpega. Without mincing words, the ultimate result this action is intended to achieve for the plaintiff is the removal of the second defendant as Chief Justice of Ghana, and as a fallout, a judge of the Supreme Court. The substratum of the plaintiff's case, as we have stated earlier, is that the second defendant is not a man of high moral character and proven integrity to be the Chief Justice. Ipso facto, a judge of the Supreme Court, since the qualifications are admittedly the same. For if the second defendant is disqualified from occupying the post of Chief Justice on grounds of lack of integrity, I do not see how he can continue to be a judge of the Supreme Court. Does this apply?
It also has persuasive application. But again, I think there is room to put this matter beyond conjecture and contention. You see, somebody does something which is read as meaning that they don't have a high moral, whatever it is. It draws you into the facts of the matter concerning C.J. Torkorno. There's a whole argument that even the issue of Pedios, etc., should not necessarily be an issue that she to answer to in the way it is being dealt with. Because there were auditors, etc., that handled those things. And then there is the issue that it was not proven beyond reasonable doubt that this was clear, etc. You know, I keep saying, there is a reason why we have a Supreme Court, and when we have doubt, we go before them. Even the justices of the Supreme Court, upon further examination of the matter, can depart from their earlier decisions. So this is useful. If we have more time, you will hear both arguments, and you'll be persuaded by some. So for me, the merit of the matter is why it is before the justices all over again. It is useful for them to go through it. If I had the time here, I may be able to canvass reasons why I think an absolutely good Chief Justice, and I'm not saying that is what C.J. Torkorno was, but I'm saying for principle, that perfect or absolutely good Chief Justice, who is found culpable in things like what we are discussing concerning C.J. Torkorno, etc., should not be removed from her post per se. Because, as many have said, including Justice Sofayaku, it does not rise up to that point. To the extent that there is that doubt, should that rise to the point of removing her from two positions, which very rarely people get to? I don't think we are doing ourselves the best favors as a country to proceed that way. So to that extent, I really want to hear the reasoning behind why this should remain so going forward. Because it will influence what happens in future. So it is very good that she's taking it where she's taking it. And I want to hear what the justice has to say about it.
Quick clarification. She's taken it to the High Court.
The High Court.
Taking it to the High Court. All right. So Martin Kpebu is here. This is an exciting conversation to have you both on. All right. Yes. I mean, it's, it's really intellectually compelling. But you see, for some, it is actually quite a simple matter. It's actually quite simple. That 1464 exists. It is there. Yeah. So why go through a process that doesn't include 1464, and then at the end of it, release an outcome that includes the outcome of 1464. Why not simply go through 1464 as well before you then have the outcome? Numbers, but I'm simply saying, Chief Justice removal is under 1462, I believe. Five. Forgive me. Right? So you've done 1465, and you've removed her as Chief Justice. You have not done 1464, but you have removed her as Supreme Court judge. Why? 1464 exists. So go through that to remove her as Supreme Court judge.
Okay. No, I would not, because the 1464 and 5 are many. Let me just be sure that when we said 5, that was it. Yeah. You see, let's do this, Kojo. The simple matter is this: the Supreme Court has held. Okay, so 1466 is a Chief Justice.
1466. Thank you.
Exactly. So 5 is the recommendation for the removal of a Superior Court judge.
Right.
Look, it's simple. The Supreme Court has held, in 2 cases, and you even 3, because you mentioned the Aban case. In the J2, and then in Justice Torkorno's own case, they say it's a consolidated process. It's 2. It's a consolidated process of removal as a Supreme Court judge and removal as a Chief Justice. Let me read a short dictum by Justice Tanko in the recent one. So if that is the case, I'm wondering why they didn't take issue with the ruling of the Supreme Court when it was given, because Justice Tanko was very clear, Amadou Tanko, was very clear that, look, this process involves the removal of the Chief Justice as Chief Justice and also as a Supreme Court judge. That's why, let me just go straight to it. It says this: I have arrived at the conclusion that this application must fail without relish, mindful of the fact that the applicant, the Honorable Lady Chief Justice of the Republic, is going through a process that may define her career on the bench as Chief Justice and as a judge. Chief Justice and as a judge is 2. Then we go to the one you read earlier, Pega. Then there is a J-Chum. I've been scrolling since I came, because I wanted to get the page in a J-Chum. A J-Chum, a J-Chum case, that's Dateba. He gave the, the lead opinion of the Supreme Court, and Justice Sofia Kufu and the rest concurred. Of course, Justice Sofia Kufu later on wrote a small opinion where she stated her misgivings about the nebulous nature of stated misbehavior, asking that there should be more flesh, and also in terms of the procedure, more flesh. But generally, she concurred with Justice Dateba. So it's been very, known to us in the legal community that it's a dual process, 2 in 1.
That first reference you made,
yes,
and the quote that you read,
yes,
I note that, and I'm just trying to be fair here, I note that he says that the procedures that they are going through may have, he said, may affect Justice Torkorno's career as a Chief Justice and as a judge.
Yeah.
I don't know that we are being fair if we say that means may remove her as a Chief Justice and as a judge.
Oh, that's the meaning.
Because you can affect her career as a Chief Justice in one way and affect her career as a judge in another way.
I get it. The devil's advocate.
Yeah, it's only fair to point that out, right?
Yeah, why not? But for us as practitioners, it's not a question that really excites our mind that much. You see how Blessed took it, and you yourself, you earlier referred to it. It will be incongruent to say that those facts that have been proven against her relate to her office only as Chief Justice. Those same facts, let's go over this. We lost over 300,000 in terms of per diem and tickets, right? And somebody is saying that these are trivial. This cannot meet the threshold of failing to keep the public purse, and so the Chief Justice cannot be removed in the dual capacity. We are joking. Look,